Perfect. Okay, guys, let's start. So, how many meetings are we left with before we go for the end of semester? Huh? Just three? This is okay. This week, okay. Let's just check so that we get prepared for our I think we have 3 meetings left, isn't it? 3 meetings left. Eh? Oh no. It can't be 5 meetings. Because we met last time. The first week of November will be the last. Because you have exams from 11. Then you have Grace Week. Not Grace Kirembe Week. 2 weeks, which is 2 meetings, So we have, let me just show you this. Should sit together there. So we have, this is, have you seen the exams? It's November 11, 17, isn't it? And today is 21, So we have 2 weeks remaining, This week, and then next week, we're done. I think for Grace and others, maybe we can ask for some more days, Otherwise, Grace, but I hope you catch up, no problem anyway. Okay. So this is a toilet reporting. Okay. Not for journalists. Not for journalists. There we go. So we will be cruising. See that? So think about this one. You are reporting a case involving a well-known local businessman who is charged with shoplifting. He asks the court not to allow his address to be read out, as it would be embarrassing given his high profile in the community. The magistrates agree, but can you provide an argument to change their minds? Adi Mlandu should be held in camera. So a case can be held in camera, which is in private, okay? Meaning it is not in the court, open court. But if a case is held in camera, doesn't mean that case cannot be reported by journalists. No, unless there are reasons provided, maybe security reasons and others. Then, so in camera or in private, but it can also be held in open court. Open court is where that courtroom, where one can sit there, isn't it? Okay. But then the other one can be held in chambers. A judge decides to hold a court in his office or in the library, anywhere. Okay? So mark those terms. In chambers, in camera or stroke private. All right? Mark those terms. Make a differences. The other thing that you need to know is you should know that restrictions, okay, these are the general terminologies which you need to understand. Hearings should be held in public. A court can only exclude the public if it has a legal power to do so, not just anyhow. All courts have a common law power to restrict public access where it could frustrate the administration of justice. So these are the restrictions. That's check here. Statute and court rules allow exclusion in specific circumstances. These are circumstances. If you can check your document, you'll find that this is on page, what page is this one? This page 108, eh? Please read that one about what are the areas that a court can restrict somebody, eh? Child, witness in sex offenses, special measures of directions, hearing in camera for reasons of national security or protection of identity, youth court proceedings, applications for further detention, cases under the Official Secrets Act. Yeah. What information can you get from the criminal courts? Check that one. Please check that one again. So as daily lists should be available to the press. Details of committal proceedings should be displayed within a day. Prosecution material should be given to the press where possible. Names and addresses of defendants should be read in open court. Okay. I've told you the page, isn't it? About that. Those about criminal. Access restrictions. And we're talking about restrictions, isn't it? Access restriction in the civil courts. What are these restrictions to the civil courts? The civil procedure rules state when hearings can be held in private. In private, we still use in camera, but that's in private. They change, our friends in the UK change to, okay? But it's all the same. Family proceedings are subject to special rules. The possession cases are normally held in private, but can be held in open court. Applications for injunctions may be public or private, depending on the court. Okay. So here, restrictions on access in general, but these are restrictions for criminals, criminal cases, and information from criminal cases, access restriction in civil courts, information from the civil courts. So you should know what are the areas that are restricted and which ones are not, isn't it? Yeah. So claim forms are open to inspection, judgments are published online, witnesses are published online. Witness statements should be available for public inspection. Documents disclosed during a case should be available to the press. Okay. So you can also try to check the questions here and attempt them yourselves. For example, what is the difference between in-camera and chambers? Test yourself with this question. But questions like human rights, okay, list 4 circumstances in which the Human Rights Act 1998 allows the media to be excluded from all or part of trial. You may need to know something about the Human Rights Act of 1998. But this is mostly in the UK, so it may not be applicable, perhaps in Malawi. Or is it applicable? What about our Human Rights Commission? You arrive at your local court to report a case, only to be told that the judge has decided to exclude the press from the courtroom. What's the first thing you should do? Name 4 situations in which a court could use its common law power to exclude the press from trial. So read all this and then try it and understand them. And you should know that what you're reporting here is the UK scenario, isn't it? Then try to relate with what's happening in Malawi. Okay. Next, you should also look at the general reporting restriction under the Contempt of Court Act. Contempt of court, something that you go against the courts. Okay. So briefly, I'll rush to the summary part. Okay. The summary part of this. Okay. Okay. What's the summary for this? These are the summary. Okay. Excuse me. Okay. So here is law in practice. For example, they say is an order in place that's contempt. Eh? If an order imposing reporting restrictions of any kind is in place, a notice will usually be posted up in the court complex. However, this is an example of what the media would be saying. The media is concerned because they will not be, they have been excluded. Tony Jaffa, head of media at Solicitors Foot Honesty, points out that some courts are more careful about doing this than others. The practice directions instructing courts to notify the press about orders make it clear that even if this is not done, the responsibility for finding out whether an order exists and following it remains with the press. So the fact that a notice has not been put up will not help you if you break it because you did not know it existed. If you are reporting a case where you would expect that an order might be made, but there is no notice to that effect, always check with the court staff. Okay, what they're meaning here, if it is not, if there's an order that you don't report the case, then you are reporting it. That would be in contempt. But then if there is no notice anywhere, it's just verbal, it will be difficult to be challenged. You say, I didn't see it anywhere. But sometimes to avoid such collusion, such clashes with the court, you ask, is this case going open to the public or not? Isn't it? You have to be careful. Some of the things, when you go to court, find out first. I've come here to cover this case. Is it open to the public? Ah, what? Okay. I'm Teresa Pili from Unireal. Okay. So, okay. Let's summarize. So this is some. The other thing that you need to know on here, just in summary, is these are orders that's based on the UK. These are all order. Reporting restriction under Contempt of Court Act 1981. They are not very much different from what is happening in Mali because most of these laws were copied from our colonial masters. So courts can order reporting restrictions where necessary to avoid substantial risk of prejudice in any case, in any type of case. So the courts have that jurisdiction. The order must be necessary. So you means for you, you have to go and read. If they say the order must be necessary, what is it? You go back, isn't it? It's there up there. The risk of prejudice must be substantial. There would be a risk. So you have to go in detail and read what is the risks. The order must remove the risk. Okay. So if the order is there, it means there will be no risk. That should show. Proceedings must be current, imminent, or pending. Postponement must be for a specific time. The public interest must be considered. So this is order section 4, subsection 2. But it's all is up to us now to go in detail, read those sections above there, isn't it? Okay. Order section 11, that's it. This allows courts to ban publication of any matter that has been withheld from public during court proceedings. So these are some of the examples. The information has not been given in court. So anything outside court, an order is necessary in the interests of justice. So neither order should be given merely to spare defendants embarrassment. No, not that we don't want the defendant to be embarrassed, but should be not something that can derail justice. Both orders must be put into writing, stating the purpose, scope, and duration. So other reporting restrictions, statutory restrictions also apply to divorce and maintenance proceedings, indecent media evidence. So these are test questions. Okay. In which courts can these orders be made? Okay. So test yourself with this question. What details can you report about a divorce case? All right. It also gives you sources online. Reporting restriction, any criminal cases, what are these? When you have criminal cases. Okay. So there can be reporting restriction on hearings before trial. That's what we call preliminary hearings. You can go in detail on that one. They also have when are the restrictions lifted? So the defendant can have them lift. You can lift the maybe the defendant thinks if the case is tried in secret, he might not have fair trial. So if the majority, the public listens or have access to the case, the judges or the other might be conscious about the way they pass the judgment. So, and when do these restrictions end? So the reporting restrictions come to an end when one of the events below occurs. The magistrates accept that there is insufficient evidence and dismiss the case. All the defendants have been tried at the court, at the criminal court. The court decides to try one or more defendants summarily. That's in this situation, the case or the press can report the summary trial, even if it takes place before that of the defendants who are going to be tried in the higher court. Okay. Let's look at this one, the committers for sentencing. What do we say? Someone that is committed for sentencing means what? It was explained in chapter 3. Please read about committers for sentencing. So as explained in chapter 3, there are limits on the sentences which magistrates can impose. As a result, magistrates who have found a defendant guilty, they often decide that the offense justifies a more serious sentence than they can order. And so we send the defendant to the higher court for sentencing. All this is usually described as committing the defendant to the court. It is not a preliminary hearing like those described in this page, because the defendant has already been tried and so restriction. So I don't know, in my find out, but what I know in my even the magistrate, before they decide whether they can take up the case or not, they can still commit somebody to a higher court for trial. But in this case, they're telling us they are committed to the higher court for sentencing. I mean, the magistrate has tried had done all the processes up to judgment level. But sentencing, because it's beyond the jurisdiction of the magistrate, it requires maybe more years. Magistrates just give and say, can only sentence somebody to 5 years. But this person found guilty in this criminal case, maybe it's more than that. So he will say, no, I'm committing to the high court for sentencing. Okay. So you need to also know issue about bail applications, pre-trial hearings, preparatory hearings. What are these? Applications to dismiss. Where a defendant has been committed to the ground for trial on either way offense that can go to can be summary or can be, this type of offense, yes, either way offense, can be criminal either way or can be summary, isn't it? Okay. Serious fraud cases. Some cases of serious fraud can bypass the usual committal proceeding and be transferred straight to the High Court. Transfer of sexual offense cases involving children. When a case involves sexual offense, the Criminal Justice Act 1991 provides procedure by which the normal rules on the committed for trial be bypassed and the case transferred direct to the Crown Court without any examination by a magistrate. This procedure is used when the Director of Public Prosecution is satisfied that the following three conditions apply. The nature of the offense makes it suitable for trial in the Crown Court. The child who is either the victim or a witness will be called to give evidence. The case should be moved to the higher court without delay in order to avoid any prejudice to the welfare of the child. Restriction in rape and sexual offenses. The person's name, their address, their school or any other education establishment they attend, their place of work, any still or moving pictures of them. Jigsaw identification, law in practice. The main danger in reporting sexual offense cases lies in inadvertently identifying the victim through what is known as jigsaw identification, advises Tony Jaffa, head of media at Solicitors Foot and Stay. This arises where, although the name of the victim is never mentioned, details which are given can be pieced together, perhaps by someone who knows the victim, to work out his or her identity. An example would be a case where a man rapes his stepdaughter and you report that the offense happened 10 years ago when the victim was 15. If you also mention a stepdaughter who is 25. Okay. It doesn't take a genius to work out who the victim probably was. In those cases, if the facts are especially newsworthy and you want to report them, the safest option is not to name the defendant. So if you think you can reveal the victim by naming the defendant, then don't mention both. Eh? That's what they're saying. So jigsaw identification is a particular problem for broadcasters. Okay. Given that running news coverage means there may be a series of different reports over a 24-hour period, often supplemented by online coverage, with each story adding different details to the picture in compiling each new report. You should look at what has been published before and ask yourself whether what you are planning to add could provide enough when put together with what has already been said to identify the victim. Remember that it is not necessary for the general public to be able to work out who you are talking about. You can be guilty under the Act if acquaintances, friends, or even family members can identify the victim from the coverage. So, you should understand what the jigsaw identification is and why it is a challenge in broadcast. Eh? Okay. Offenses covered by the restrictions. So, the restriction described apply not only to rape but also to most of the offenses which contain sexual element, including offenses which do not involve any physical contact, such as indecent exposure. These include rape. For the identification of this offense, which is now wider than often believed, attempted rape, aiding, abetting, concealing, and procuring rape, incitement to rape, conspiracy to rape, burglary with intent to rape, offenses involving indecency or sexual activity with children, indecent exposure, internet grooming, trafficking for sexual exploitation, voyeurism. So, understand those terms, what they mean, eh? Read. I know Teresa is asking, what is voyeurism, isn't it? Let's check together. But I also have to put it somewhere here for it not to give me some troubles. Okay, voyeurism. Voyeurism, okay, for me it comes from French, the word voyage, voyer, but to sightseeing, seeing. But voyage, it's also going to be traveling. Okay. But let's confirm this. It's opening here. We'll come back to that. Let's continue reading first. So there would be more than these examples, depending on the on the situation, the culture, environment, and others. So read those things, those issues on restrictions. So you can have restriction in criminal cases. That is fine. Okay. So these are the reporting restriction appeals against acquittal as we saw in chapter. So these are chapter 3. There are now several ways in which the prosecution can appeal against an acquittal, and specific reporting restrictions may apply to these. Tainted trials, when the prosecution seeks to quash an acquittal because their original trial was tainted. Tainted means it was marred with some doubts, some miscarriage of justice, sort of. So the court can order any report of the original case to be postponed until after the new trial is finished. So you're not going to be reporting on something that has been quashed. Wait for a new trial to take place. Then you have stopped trials in case the trial had been stopped. In this case, a judge can stop a trial if it becomes apparent that there is insufficient evidence to support conviction. So where this happens, the Criminal Justice Act allows the prosecution to appeal against the decision. Okay? The name of the court and the judge. Okay, so the Act provides that reports of the appeal hearing can only contain the name of the court and the judge. Okay. The names, ages, home address, and occupation of the defendants and witnesses, the verses or summary of them, the names of the lawyers involved, if proceedings are adjourned, the place and time to which they are adjourned, arrangements for bail, whether the defendant was granted or represented by the Legal Services Commission, but what here we have what the equivalent of Legal Services Commission? I'm at legal aid, isn't it? Well, the legal aid. What used to be called legal aid? Oh, they call it legal aid. They used to call legal aid there. But here, we still call it legal aid, okay? So it is a criminal offense to break these provisions. Let's look at it again. A judge can stop a trial if it becomes apparent that there is insufficient evidence to support a conviction. So where this happens, the Criminal Justice Act 2003 allows the prosecution to appeal against the decision. The Act provides that the reports of the appeal here can only contain, the rest can be left out. Okay? So, chapter summary for this is restrictions on hearing before a trial. Special reporting restriction apply to preliminary hearings in the magistrate's court, bail applications, preliminary hearings, preparatory hearings at the start of long and or complex trials, application to dismiss a case for lack of evidence, transfer of serious fraud cases, transfer of sexual offenses involving children. Okay? So these are restrictions. The restriction on rape and sexual offense, once a complaint is made, Once a complaint is made, it's an offense to publish anything relating to the complaint that may identify them as the person making the allegation. Once someone has been accused, no matter at all which might identify the complainant, as the alleged victim can be published. This decision lasts for the complainant's lifetime and applies to most sexual offenses. Lifetime, never to be revealed. Restriction on the pleas in mitigation. Publication of arguments which are derogatory to someone. Derogatory means, what does derogatory mean? The term derogatory means what? Hmm? Say something, to do something like you're inserting monyoza. Okay. Protecting vulnerable witnesses. Courts can prohibit publication of anything which could identify vulnerable witnesses where fear or distress of being identified would otherwise affect the quality of evidence or their cooperation with the party to the proceedings in preparing their case. Reporting, these are summaries of the chapter. So reporting restrictions on appeals against acquittal. So read this, you don't understand, get your dictionary and understand the terms. Okay. So you test your knowledge with this one. Okay. A report of committal proceedings in the Crown Court reads, James Jones, 36, appeared before magistrates this morning, charged with burglary. Ms. Jane Smith, prosecuting, told the court that the defendant had been caught red-handed leaving a luxury flat in King Street. He later admitted burgling 10 other apartments in the same block. The magistrates refused bail, with the chairman, Jack Clark, explaining that there was a clear risk that the defendant would offend again before the trial. Which bits of the report should be removed before publishing? Yeah. Okay. And why? Okay. You are reporting a bail application. The prosecution opposes bail on the ground that the defendant is likely to try to leave the country before the trial. But the magistrate grant bail provided the defendant surrenders his passport. What can you put in the report? Okay. Oh, okay, fine. The other one, explain the difference between pretrial hearing and preparatory hearing. Why is it prohibited to report rulings made in pretrial hearings? When do reporting restriction on preparatory hearings end? Yeah. Which of these sentences is premised on a report of a rape trial? John Smith is charged with the rape of his niece. John Smith is charged with the rape of his niece, Jane. A Birmingham man has been charged with the rape of his niece. A plumber of Hope Street, Birmingham, has been charged with raping his niece. A care assistant from Birmingham told the court how she was raped by her uncle. Which of these sentences is premised in a report of a rape trial? And why? We see these things, eh? Okay. Okay, so read more on this. Reporting restrictions concerning children. Okay. So these are the youth courts and others, right? In law in practice, this one has everything. Law in practice, you find out. So take care with naming adults who are involved in your youth proceedings, such as witnesses. Well, there is no ban on naming anyone aged over 18. Naming an adult could accidentally provide information which could identify someone under 18 in the case, e.g., if they are related. Essentially, if someone who did not already know the details of the case could name the child as a result of reading the report. There is a risk of committing an offense under the Act. Yeah. So there you go. These are restrictions on youth court anonymity lasts only until the defendant's 18th birthday. So if a defendant is soon to turn 18, you may not need to bother asking the court to lift anonymity. So you will be able to write about the case after their birthday anyway. So Advocate Stone Jaffa solicitors foot Anessa. This also means that once an offender turns 18, you are free to write about their youth court history. So if they are convicted again as an adult, it is premised to use this as background. But children can also be found in adult courts. So, when a juvenile is involved in proceedings before any court, except a youth court, their age does not automatically create any reporting restriction. However, that section, that's in the UK, allows the court to order that newspaper or broadcast reports of the proceedings may not reveal the name, address of school of the young person, or include any details designed to lead to the young person being identified. No pictures of the young person can be published or broadcast. So such orders can cover any person under 18 who is concerned with proceedings, including witnesses and victims, as well as defendants, but not victims who are dead. Okay. Okay. Very young children, you can also do this. Naming dead children. There have been cases where judges have attempted to use orders to ban publication of the names of dead children, even though the names have already been made public, for example, in inquest reports or news stories about the deaths. Okay. So these are we're going through fast, so that you have an idea what, according to Tony Jaffa, head of media at solicitors Fute Anstey, Section 39, orders are the single most common type of reporting restriction to be wrongly imposed by courts. We deal with several cases every month of courts trying to impose Section 39, orders banning identifying of adults or dead children or children who are not involved in the proceedings. The legislation makes it absolutely clear that it does not cover adults or children who are not involved in the proceedings. So I would advise court reporters always to have a copy of the relevant section with them so they can quote from it. The legislation itself doesn't specify that dead children are not covered, but that is well established now. So it may also be useful to be able to, this is about, find out about this in the Malawi scenario. Voila. Okay. Okay. Remember this, we talked about this ASPOS, isn't it? Okay. Can be ordered against anyone over the age of 10 and around half the issue against the people under 18. Okay. In this situation, the reporting restriction that apply depend on how the ASPO is imposed by magistrate in civil proceedings or in youth court where a juvenile has been convicted of a criminal offense. This is often known as bottom on. SPO. Okay. Okay. I want to look at the summary for this. It's a whole big book, this one, eh? And that's where the syllabus is premised, which you're using. Eh? Okay. Chapter chapter. Youth Court Cases, Section 47 of the Children. This is the UK, wasn't it? And Young Persons Act 1933. Oh. Give the press a right to attend youth court proceedings. Unless restrictions are lifted, the press may not publish anything that could identify a defendant, victim, or witness under 18. Children in adult courts. On this one, no automatic restrictions apply, but courts can ban publication of anything that could identify a witness, defendant, or victim under 18. Jigsaw identification. Take note of that. The Press Complaints Commission requires precautions against identifying via more than one publication. Antisocial behavior orders. No automatic restriction applied to antisocial behavior orders from civil proceedings, but a Section 39 order may be made. In youth court proceedings, the press cannot name the recipient of the antisocial order or antisocial behavior orders. Family proceedings, provision of this. Test your knowledge. You have been sent to report on a youth court case, but the court clerk refuses to let you in, stating that youth courts are closed to the public. Which statute gives you the right to be there? Eh? Okay. You are reporting a youth case for which restrictions have not been lifted. Which of these statements can you make in your report? Which of them can you? Okay. So, if you are given this, you should also have to give a reason why that statement can be given and why that statement cannot be given in your report, isn't it? Yes. Yes, exactly. Yeah. Choose one and then give reason. Right? You should also be able to say why you have not chosen this other one. Also, small explanation. Yeah. Voila. You are reporting. You are reporting a case where a man is accused of murdering his 18-month-old daughter. The judge imposes section this one, banning the press from identifying the little girl. What arguments would you use to get the order lifted? What arguments would you use if the charge was not murder but assault? Okay. And so what is this? What's a jigsaw identification? Okay. What is a jigsaw identification? Okay. Right. Reporting inquests. Okay. An inquest is held when a death, that's an inquest, is sudden and unexpected, though where a death is sudden but a postmortem examination shows it was due to natural causes, a coroner may rule that there is no need for an inquest, or is suspected to be unnatural or violent, occurred in certain types of custody. So, inquest verdicts, natural causes can be lawful killing rather, and lawful killing. Lawful killing? Dependence on drugs, want of attention at birth, suicide, accident or misadventure, industrial disease. Open verdict. This is the verdict given when there is not enough evidence. So an inquest happens when there are some death, sudden or suspected death. So there are criminal proceedings and appeals from inquests. Treasure trove. What is this? You can check at this. Treasure trove. Inquests also have a second, completely different role of investigating variable archaeological finds. Although this role is centuries old, it is now dictated by that's in the UK. Check, go back and go check, go into the history. So which provide that if an object found in the ground is at least 200 years old and fits certain other criteria, it is treasure. Anyone who finds an item that might be treasure is required by law to report the find to the local coroner within 14 days. This find is then notified to a local museum, which, if it believes the find may be treasure, inform the British Museum or the... So if you get something, my mom and likes, you test it, if it's 200 years old, you're going to need to report that to the museum. Okay. Inquest and contempt of court. Inquest and defamation. For the purpose of defamation, inquests are covered by absolute privilege, which means you cannot be sued for reporting anything said during the proceedings, as so long as your report is fair, accurate, and contemporaneously. So see chapter 14 for that. Okay, that is something you also need to take note of. Okay. Reporting restrictions. Okay. Getting to know the coroner's office. What are these? Law in practice. Studio. Despite the fact that the Home Office encourages coroners to keep the press informed about forthcoming inquests, this does not always happen automatically, even where a case is of obvious interest to the press. Okay. A coroner, that one who is someone in charge of inquest, isn't it? Yeah. So you can be asked to do that or not. But mostly, they may not, like this is an example of what happens, should the press attend or not. So here is the death of this person. She's a popular actress. She's in a hospital city, was not attended by any members of the press because no one in the media had known it was taking place. With this in mind, it is worth calling the coroner's office from time to time to check. So they may not inform you, even in the court. They will not tell you that today there is a good case of interest. Come and cover. It's up to you to find out, isn't it? Calling, finding out which case is there today and what time. Okay. Okay. So, in cases involving personal grief or shock, inquiries and approaches must be made with sympathy and discretion, and publication handled sensitively. This should not restrict the right to report legal proceedings such as inquests. When reporting suicide, care should be taken to avoid excessive detail about method used. So here are some of the broadcasting code. Include the following provision, which, while not limited to reports of inquest, will often be relevant to such reports. People in a state of distress should not be put under pressure to take part in program or provide interviews unless it is warranted. Broadcasters should try to reduce the potential distress to victims and relatives when making or broadcasting programs intended to examine past events that involve trauma to individuals, including crime, unless it is warranted to do otherwise. As far as reasonably practicable, surviving victims and or the immediate families should be told that the coverage is planned, even if the events or material to be broadcast have been in the public domain in the past. You see that? This, penda pacha tunankani kamalemba nkani. We should think about achibari nkani zoopya nkati zimene zoma inquests. We must think about if this one was my relative who died. Issue, for example, of the plane crash and the like, there's an inquest. We should think there, Kuliana, Abariao, who are still crying, or who can still be reminded if we don't cover properly. Okay. This one. At least an institution, you can check. This code of practice states that this PCC is an institution. As much as the Ofcom, check what they stand for. Yeah. All right. So excuse me. We also should know reporting tribunals. This is reporting tribunals and inquiries. Okay. So we have types of tribunal. We have the asylum and immigration tribunal, the criminal injuries compensation appeal. This is the UK. Here they are handled, most of these things are handled so what is a tribunal? Why do you call it tribunal? What is it? Okay. Which tribunals you come across will depend on the area of journalism you work in. Those considered below are the ones journalists are more likely to come across, in addition to the employment tribunal, which is examined until at the end of this chapter. If you're working for a trade or specialist publication, it's well worth making yourself familiar with the rules of any specialist tribunals in the area. Okay. Okay, let me digress a little bit, talk about something which about law of journalism. Okay, let's see this. So sometimes you can be asked a question like this. Maybe you read the story provided. This example. Provided and rate it on a 5-point Rickett scale. Rickett scale on the following items. Okay. And give a reason for the score. Okay, I'll explain how this is, what this is modifying to it. So, you okay. So you can have a story. So when you have that story, maybe you want to to see if that story has the okay okay can take this example. So if the story meets the following criteria, okay, okay. So you have here statement, okay, statement. Here you have what we call serial number. Then you have here 1, 2, 3, 4, 5. Okay. So somebody asks you the story. It's the you are given a story. Score that story has a verdict. Okay, no, let me. So these are statements. Let me have this one. 1, 2, 3, 4. Okay. Oh, thank you. 4, 5. This is what we call a Rickett scale. Okay. Where you agree, it can be strongly agree. Strongly agree, and strongly agree is SA. Okay. Equal to, it can be a 5. It means if that story, I'll put different statements here, isn't it? I don't this which are relevant. Let me check. There agree and it's A. It's not an agreement. We give a 4. Neutral. Sometimes you don't have a stand, and it's an N. That's an N. So you just say it's a 3. And then sometimes you disagree, which is a D, which is then a 2. And finally, you strongly disagree. You strongly disagree. Oh my goodness. Which is SD. You see that, Okay. So this is, there are 5, isn't it? You see that, That's why we call them 5-point Rickett scale because of this, So you can either agree with a statement or you can be neutral, just agree. But so if this one that, let's say, the story you're reading, The story you're reading has revealed the underage victim. If you agree or you disagree, let me put it vice versa here. 4. 2, 1. So if you strongly disagree, if in that story you are given a story to read, and that story, the first thing we said, the story has revealed the underage victim details, or identity. If you disagree, you can just say, you can just put a 1 there. Okay? Or just a tick if you want, or just a 1 there.